Good day, ladies and gentlemen, and welcome to your Foley and Lardner Interworking Conference Call. At this time, all participants are in a listen-only mode. As a reminder, this conference is being recorded. I would now like to turn the conference over to our host, Ms. Kristen Martin. Ma'am, you may begin.
Thank you. On behalf of Foley and Lardner, we would like to thank you all for participating in our Interworkings web conference series. Today's conference will last 60 minutes. During this time, you may ask questions by selecting the Q&A button and typing in your question. We will try to answer all of your questions. However, if we run out of time, we will follow up with you individually after the conference. If you would like to print or save a copy of the PowerPoint presentation, you may do so by selecting the printer icon at the bottom right-hand corner of your screen and downloading. Finally, please note that in order to receive CLE credit, you must be logged into both the computer as well as the phone line. I would now like to introduce you to your speakers for today. First, we have Mr. John Birmingham, Partner and Chair of the Labor and Employment Law Practice out of our Detroit office. We also have John Douglas, Partner with the Labor and Employment Group, and he's out of our San Francisco office. And Michael Leffel, Partner and Co-Chair of the firm's Class Action Group out of our Madison office. John, you may begin.
Great. Well, hey, I want to welcome everybody to participate today in the conference. This case and what we're going to talk about today, I think, is very important. It continues a trend in promoting arbitration and potentially narrowing class actions. And judging by some of the media coverage, I think it's a real game changer. The reach is still not completely clear, but if you believe the New York Times and the Washington Post and some consumer and civil rights groups, this should have very significant ramifications in the class action world. I think especially coupled with the Walmart case that recently came down that narrowed the scope of class actions in labor and employment, this case is very significant. There are a lot of open questions to the case that we hope to delve into today, including, will it allow companies to avoid class actions in consumer and employment context? Are there still avenues to attack class action waivers in arbitration agreements? I think a big issue that's going to come up is, will Congress step in? Will the National Labor Relations Board step in? Will regulatory agencies step in? I think that this will get very significant. There will be a lot of pressure from various groups to have these agencies and Congress try to narrow or essentially legislatively overrule what the Supreme Court has done here. Will it stop consumer suits, consumer regular lawsuits? I mean, Justice Breyer says in his opinion, what rational lawyer is going to take a case that's worth $30? So is this going to narrow and reduce the number of cases or disputes that are litigated, even in arbitration in the consumer context? And then lastly, we want to talk about, how can companies and how can employers take advantage of the Supreme Court decision? Traditionally there have been a lot of pluses and minuses to arbitration, which we're going to cover also. But this could be a reason, this Supreme Court decision could be a reason that kind of tips the scales and should make companies and employers take a fresh look at using mandatory arbitration to resolve disputes and potentially to avoid class actions. We're going to save a little time at the end for some Q&A, so have your questions ready, and we'll go from there. So I think with that kind of introduction, I'm going to turn it over to Michael Leffel, who's going to explain the AT&T Mobility Concepcion decision and some of the historical background of it. Michael?
Thanks, John, for that introduction, and I think that gives us a good groundwork for what we're talking about today. In a lot of ways, this decision has been a long time coming. The Supreme Court has had a number of opportunities to touch upon the sort of interplay between arbitration agreements and the right to get a class action, as well as the sort of what was the underlying issue here, the application of unconscionability law, generally applicable contract law, to the enforcement of arbitration clauses. And it started that, way back in 2000, probably with some of the Green Tree versus Randolph and then the Green Tree versus Basel cases, but has always sidestep the ultimate issue that they addressed in Concepcion. So I'm going to start with just a little bit of a background about the decision and then talk about some of the particulars before John and John talk a little bit more about its particular impact for people who are concerned about labor and employment law. To start with, this case was brought by the Concepcions. There was also another plaintiff who was representing a class action, and the cases were consolidated. But what they were complaining about was a practice by AT&T of advertising. If you sign up for our cellular service, we will provide you with a, quote, free phone. So the Concepcions got a couple of free phones and then were shocked to find out that they had to pay a little over $30 in sales tax. And so they felt that that wasn't really a free phone, and they did what anybody would do. They went out and filed a large lawsuit. And the issue came up right away in the case, and the important issue that came up for our purposes today in the case was the fact that the cellular agreement that the Concepcions had signed up for included an arbitration provision. And that was what was going to be discussed by the court. The arbitration provision said only individual arbitrations were permitted, no class or representative actions in or outside of arbitration. It was very popular at the time in California to sort of force these things into class arbitration, even if you somehow could get out of the typical litigation track out of court. The contract also permitted AT&T to amend the contract through notice procedures. That really wasn't an issue in the Supreme Court, but it is interesting to note that that's how, in fact, the particular arbitration clause at issue was added, was by an amendment that was sent out as part of the standard notice and amendment process that AT&T followed. Sorry, I just got a little tied up there on our slides. The lower courts, both the district court and the Ninth Circuit, had held that, look, there is a rule called the Discover Bank Rule in California. It's a state-created rule. And based on California state law, it will invalidate certain class action waivers of class actions or arbitrations that do not permit class arbitration. And what the Discover Bank Rule says is we're going to invalidate those clauses or force you into a class arbitration when you have certain factors met. It's got to be a consumer contract of adhesion, a standard form boilerplate contract that people are sort of forced to take on a take-it-or-leave-it basis. It's got to be a small amount of money at issue, although, as the Supreme Court pointed out in Justice Scalia's opinion, that amount varied. Some cases in California said as much as $4,000 at issue was still small. And third, the party with the inferior bargaining position, obviously the consumer in this case, had to allege that the party with the superior bargaining power has carried out a scheme to deliberately cheat large numbers of consumers out of individually small sums of money. Now, Justice Scalia, commenting on that in his majority opinion in Concepcion, also pointed out that there's really not a lot of teeth to that. It merely takes some allegations, and any time you've got an allegation of a claim of deceit or fraud, you're going to be able to easily meet that standard. So the question for the court was, how does that interact with the Federal Arbitration Act? And the Federal Arbitration Act it requires courts to enforce arbitration agreements just as they would enforce any other term. And it has repeatedly been held to reflect a liberal federal policy favoring arbitration. So in short, if you're covered under the Federal Arbitration Act, and I will note that Concepcion itself only applies if this is a case governed by the Federal Arbitration Act, and I know John's going to talk a little bit about that later. But if you're covered by the Federal Arbitration Act and the parties have agreed to arbitrate and the claims that are at issue fall within the scope of that agreement, then upon proper motion or a petition to the court must order the parties to arbitrate. However, the arbitration agreements can be challenged just like any other contract could be challenged. So if there is some grounds, generally applicable grounds, for challenging a regular contract at law or in equity, then that can be challenged. And here, in the Concepcion case, the challenge was based on sort of a hybrid of unconscionability and a lot of public policy. And that's what the Ninth Circuit and the District Court had held. Well, the Supreme Court took a look at that, and based on the Federal Arbitration Act and the Supreme Court's own history of interpreting that act, said that the Federal Arbitration Act preempts the Discover Bank rule. And basically they did that because the majority rejected the argument that any generally applicable law, such as unconscionability in this case, could support the Discover Bank rule when it's being used to effectively target arbitration agreements. In other words, the court's saying, look, if this really goes to contract formation, we're talking about duress or fraud, then that's an issue that could be used. It's not specific to arbitration. But when you look at a situation and you say, well, you're denying somebody the right to class arbitration. We don't like that form of arbitration. We think that's unconscionable. You're really treating arbitration agreements differently. And the words that the court uses a couple of times is essentially, if you have a generally applicable law to invalidate a contract that is being used specifically to disfavor arbitration, and disfavor arbitration was the phrase they used, then that's not going to be permissible. That's going to be preempted by the Federal Arbitration Act. I also note here that there was a lot made in the decisions below, and certainly in the Discover Bank rule about the fact that these were adhesion contracts, which typically have a bad name with courts, and that people were forced to take it or leave it. It was boilerplate, and Scalia, in writing the majority opinion, was not bothered by that at all. In fact, he essentially said everything's an adhesion contract these days, and that's not going to govern whether the arbitration agreement can be enforced or not. One thing that should be noted is that while striking the Discover Bank rule, and which is a big blow for attempts mainly by plaintiffs, class action lawyers, to fight these arbitration agreements as unconscionable, the court did at least comment fairly extensively on the fact that the particular agreement at issue from AT&T was relatively consumer or user-friendly. There was an informal process that you could try to resolve the claim with AT&T before you even started arbitration. After a certain time period, I think it was 30 days passed, you could proceed very easily to a consumer arbitration under the AAA's consumer rules. Claims of less than $10,000, the customer could proceed by telephone or written submission, so they didn't actually have to attend. If there was going to be an in-person arbitration, it was going to be held in the consumer's county of residence. So the lower courts and the Supreme Court, in fact, highlighted the fact that this was not going to create a significant burden for consumers to get to arbitration. Prior Supreme Court decisions have clearly suggested that even if you have an otherwise enforceable arbitration agreement, it really is written in such a one-sided way that it prevents plaintiffs from being able to go in and get a remedy because, for example, the cost is just exorbitant to go into arbitration, and the consumer would have to pay all those costs up front, even though they have only, $30 at issue, for example. That may be a bar. So I think the important takeaway from that discussion, even though I would not say that the decision hinged on that, it certainly didn't require that an arbitration agreement have all these bells and whistles. But the important takeaway, I think, is that we really need to draft arbitration agreements if we're going to include them in our employment agreements, if we're going to include them in our standard agreements with consumers. We need to draft them in such a way that we do make it easy for individuals to get in and have their day in front of the arbitrator. It doesn't have to be their day in court, but it's easy for them to get in, and it's not too expensive up front in light of what their claim is. So that's an important takeaway. Just a couple final notes on the decision as a whole. The court does mention in a footnote 6, that states remain free to take steps addressing the concerns that attend contracts of adhesion. For example, requiring class action waiver provisions in adhesive arbitration agreements to be highlighted. So it gives a little wiggle room for states to, and it's not clear whether that would have to be by statute or whether they would let a court do this, but clearly it gives some wiggle room for states to say these things can't be buried, they can't be hidden from folks. You might wonder, how does that interact with the requirement that the Federal Arbitration Act's requirement that an arbitration agreement be enforced just as any other contract would. You know, if you have a contract and everything's written in the same font size, for example, and everything else is enforceable, you would think that the arbitration agreement would be enforceable too. But the Supreme Court left a little wiggle room for states to make sure that people were aware of these arbitration provisions. They did note, though, that any steps along those lines cannot conflict with the Federal Arbitration Act or frustrate its purpose to ensure that private arbitration agreements are enforced according to their terms. So that's really where my section leaves off. I mean, I think, as I said, this was a case that was a long time coming for a lot of people. It will certainly create a much more uniform application of the Federal Arbitration Act. There were obviously a number of states like California that had been striking down arbitration agreements based primarily on unconscionability challenges, particularly when there was a class action waiver. And sometimes they would strike those on the grounds that there was a state statute that permitted you to get some form of relief or specifically permitted class actions, and therefore it was against public policy. I think all of those challenges are going to be much more difficult to make and really should be precluded based on Concepcion. But I think, as John will talk about in a little bit, I don't think that we've seen our last bit of litigation on the ability to challenge arbitration clauses based on unconscionability. I think we will see more of that, and I'll let John talk about that.
Okay, thanks, Michael. And boy, I don't want to de-emphasize how big of change this could potentially be. Every morning, I get a list of all the class and collective actions that are filed across the country in employment law cases, and it is literally, the list is dozens and dozens of cases long, and probably, you know, half of them are in California or Florida. So the potential of being able to avoid class actions, which just legal fees alone, I mean, you're looking at millions of dollars plus, you know, the potential liability that could be involved in that is a real significant change. And this is not to say that before this decision that possibility wasn't out there, but, you know, Justice Scalia in the opinion, and the majority in the opinion, really endorses the use of mandatory arbitration and firmly comes down on the side of concluding that class arbitration doesn't work and it's not available, and that if somebody agrees to an individual arbitration, you are, you know, if you can comply with the dictates of the opinion and the Federal Arbitration Act, you can avoid class action. So big potential there, I think. And John Douglas is going to talk about that a little bit more. But I just want to take a step back and talk a little bit about mandatory arbitration to begin with. You know, prior to this decision, and what are the pluses and minuses, the benefits and the weaknesses of mandatory arbitration? Because it is not a no-brainer. I mean, I have had several conversations with a number of different clients who have struggled with whether or not, in the employment arena especially, whether or not they want to require mandatory arbitration and have that be part of the conditions of employment, or have it be part of the conditions of employment for executives or certain other people. And as you're thinking about it, historically at least, the reasons for wanting to impose arbitration or settle disputes through arbitration as opposed to litigation, the biggest one that companies and employers often look at is, hey, listen, we just want to avoid the runaway jury trial. And if you have operations, especially in certain, you know, big city localities, in Texas, in Detroit, in California, there have been some huge jury verdicts where potentially a jury can run away and award, you know, tens of millions of dollars when there's not much in terms of economic damages. So that has had real appeal to certain clients who want, you know, either a cap or just a kind of a better feeling about avoiding the risk of the runaway jury. I will mention to you, though, I mean, there have been some runaway arbitration cases. I mean, just because it's not a jury doesn't mean you're going to get a perfectly rational decision maker. But I think you do increase the odds that you're going to get somebody who is not going to award something outside the bounds of what you would expect as far as a high and low. A lot of clients also have liked arbitration because of the lower costs, less discovery, and no appeals. you know, a lot of that, I think, has come from the traditional union management arbitration process, which is indisputably a lower cost, and partially because there's no discovery and you just arbitrate the case. I think some clients have found that while it is the cost is probably lower in arbitrating the case than in litigating the case. That is not always the case, and especially because you have to provide the availability of discovery in order for some of these arbitration agreements to be enforceable, especially in the civil rights or discrimination context, that you're going to potentially get just as much discovery, and the cost can be similar to and sometimes just as much as in a court case. And in fact, because a lot of employers in some states require this, pay the arbitrator's fee, there are occasions where it could be more than a court case, especially if you're in a rocket docket, which has a very fast system. And that gets to the next point. A lot of employers and companies have liked arbitration because it's faster. And it typically is faster. I mean, you're typically going to get to a resolution faster in arbitration than you are in the court system, especially in a court system that has a crowded docket like a state court system. Again, I think there are exceptions to that, but typically you can get there faster. I mean, I think some of the exceptions have to do with the fact that there really is no economic incentive for an arbitrator to push things to conclusion faster. They're oftentimes getting paid by the hour, and so there's not the incentive to end the case. There is some ability in some states to alter the statute of limitations. You can include as part of an arbitration agreement a provision where the parties agree that any litigation needs to be filed, for example, within 6 months of the adverse employment action instead of potentially 3 years, which could be what the statute of limitation provides. And there are court decisions that have upheld those contractual statute of limitations. Not all court decisions have. There are cases on the other side, but I know in the Sixth Circuit, for example, and in Michigan and some other areas, they've upheld a shortened statute of limitation. Some clients also like, or another historical plus, is the confidentiality involved in the arbitration process. Typically, litigation in federal or state court is public. It's easier to use the press. It's secrets and confidential information. It's harder to control that. It's out there in the community. It could be out there in the press. And some parties, some companies, and employers like the aspect of arbitration in that it's easier. It's not a fail-safe system, but it's easier to encapsulate what's going on and prevent the disclosure of confidential information. The last reason that employers and companies often like arbitration is flexibility. I mean, when you're in front of a federal court judge or a state court judge, you are at the mercy of that judge. If the judge says trial will begin in a month, trial is going to begin in a month. And you can try to change it. You can try to switch things around, but it really depends upon the mood and attitude of the judge. In arbitration, the parties are hiring the arbitrator. It's much easier to schedule and to change arbitration dates based upon the flexibility needs of the company and the parties on both sides. On the other hand, just looking at it, there are a number of historic minuses to arbitration. The biggest one for me as an employment lawyer is that there's little chance of summary judgment. That, especially in this day and age, I would say at least 50% of the cases that get that far are dismissed on summary judgment in the employment arena. So not having that in arbitration or having little chance of that in arbitration is a huge minus, in my opinion. It's probably the biggest reason that I give clients to strongly consider whether they really want that, especially if they operate in a jurisdiction where summary judgment is more often granted, or if they can get into federal court. It's something to strongly consider, because while summary judgment is possible in arbitration, it's very difficult to get summary judgment in arbitration. And again, it also goes back to it's not in the arbitrator's best interest to be granting summary judgment as opposed to arbitrating the case through trial and collecting fees through trial. Another big minus is no right to appeal. remember, the plus is, you're expecting that there's not a runaway jury or a runaway result, right? But if the arbitrator turns out to be somebody who's not the most rational person in the world, and remember, judges and arbitrators sometimes aren't. If everyone remembers the judge who sued for millions of dollars because the dry cleaner didn't do a good job on his pants a couple of years ago, well, that could happen in arbitration too. And there is no right, or there's a very, very limited, I shouldn't say there's no right to appeal, there's a very, very limited right to appeal an arbitrator's award. So you're stuck with the result. And, that sounds good going in potentially, but if you get a bad result, then it's not so good. So that can be a minus. Especially if you use a 3-panel arbitration, a lot of arbitrators tend to split the baby. I would advise, by the way, anybody on this call, if you can avoid it in any way possible, don't use a 3-panel arbitration, because what happens is you have 2 advocates on both sides, and then the middle person tries to reach a compromise result. I mean, the only reason to use it is if you're just trying to mitigate your potential liability and the potential for the runaway jury result. Even when you have a single arbitrator, remember, arbitrators need to get hired going into the future. And if they always rule for the employer, or if they always rule for the employee, they're not going to get picked in subsequent cases by other employers and other employees. So they have to show that they're fair and objective, and that's going to cause them to not want to have a record of supporting one side or the other. So you need to keep that in mind. Some cases need discovery, and some cases need an active magistrate. You have situations where there's going to be a lot of discovery battles in employment cases and other cases, and it's harder for an arbitrator to deal with discovery issues because he or she doesn't quite have the power of a judge, and sometimes you need that. Other cases, like non-compete cases or trade secret cases, are not appropriate for arbitration. Arbitration is faster in litigation, but it's not fast enough for non-compete or trade secret cases. So if you do have arbitration agreements, you've got to carve out those sort of claims because you certainly don't want to be compelled to go into arbitration to stop someone from violating a non-compete or a trade secret case. In some jurisdictions, the arbitration has to be mutual. That makes it more difficult, especially in the trade secret environment. And the last reason, is that sometimes the employer and the company has to pay the filing fees and has to pay the arbitrator costs for a small case. That can sometimes tip the scale in a negative balance in terms of the cost. Having said all that, and John Douglas is going to talk about how AT&T Mobility perhaps changes the game, I think the scale is fairly even, frankly, depending upon the jurisdiction and the risk aversion of a company or an employer before the AT&T Mobility case. But I do think the potential of avoiding class actions, if you are somebody that employs thousands of people and you're subject to class actions, that is a huge benefit that perhaps should cause you to consider instituting a mandatory arbitration agreement. John?
So, John, that is where I step in, and this case really caught my eye because I'm out here in California, and like you said, I get that same report every morning with the dozens and dozens of new class action filings in this state, particularly in the wage and hour context, where we have clients, and I'm sure any other lawyers who are on the line have clients who have just been bedeviled in the last dozen years by just an avalanche of wage and hour claims, rest and meal break claims, off-the-clock claims, misclassification claims, all kinds of claims, and anything that could potentially at least bring some relief to employers in that regard, I think, is something that's worth taking a close look at. I mean, there are a lot of employers out here in California that get sued repeatedly Once one case gets settled, then another gets filed by different lawyers or sometimes even the same lawyers making the same kind of allegations. And even if they have, just a small chance of prevailing on the merits, because you can aggregate such, so many small claims into such large numbers, they have significant settlement value, and they can be used, frankly, I think, as a way for plaintiffs' attorneys to generate fees for themselves. This is a new development. In many respects, listening to Michael as well, I was struck by how ironic a development it is, kind of, because here, in listening to his own Michael's description of the case, you really see that it's about kind of the tension between federal versus state control. And here, Justice Scalia, who's typically the advocate of states' rights and state law, is really rendering an opinion that significantly cuts back on the ability of state judges and state legislatures to regulate when it comes to this area of law that the federal government has seemed appropriate to step into with the Federal Arbitration Act. I think the bottom line is that for employers that have not or have historically been reluctant to go into a mandatory arbitration regime, this may be the game changer that John Birmingham talked about at the beginning of our presentation. This may be the straw that puts the weight on one side of the camel's back as opposed to the other, and that would cause us to change our mind. I will say as well, this has been a very good Supreme Court term from employers, particularly in light of the Walmart decision that's come down. I think what we see really is either because the conservative Supreme Court majority is just, pro-big business, or because they're concerned about the crowding of the federal and state court dockets that they see out there with all these class actions, they're trying to make it more difficult for people to bring and much less succeed on these kinds of cases. But as John pointed out at the beginning of our day, this is not something that I think that we can expect that the plaintiffs' bar and that consumer advocates are really going to take lying down, so to speak. And I think that we can anticipate not only congressional reaction, but as John pointed out, there is also now indications that the National Labor Relations Board is going to get involved in this. And we can surely expect that both state and federal courts that are now going to have to apply this case are going to be faced with a slew of arguments from plaintiffs' attorneys about why it is that Concepcion or AT&T Mobility, we haven't really decided at this point what the case is going to be called. A whole bunch of reasons why the case means a lot less than a lot of people have been claiming it means, that it's a much more limited decision. Talking about the congressional reaction, we've already seen what's going on there. We've seen the beginnings of it. Obviously, the reaction to the case has been kind of predictably on party lines. The Republicans go with the kind of hallelujah chorus. The Democratic reaction obviously has been the opposite. If you go on what used to be the American Association or American Trial Lawyers Association website, you see a press release, and I put some of the language there. The Supreme Court has allowed major corporations to grant themselves immunity when they cheat consumers or employees. This decision leaves Americans with practically no recourse to challenge corporate wrongdoing and gives corporations a blueprint to draft forced arbitration clauses to avoid accountability for a wide range of unfair or illegal practices. Now, I don't know if that's a fundraising pitch or what, but it certainly seems a bit I don't know if over the top. It does definitely indicate that this is a decision that has some real serious potential for interfering with class actions. And those are particularly true. It's not all class actions, frankly, that are going to be impacted by this. It's any kind of a class action, frankly, where some kind of a contract can be either put in front of you for you to read or in some way or another, so that you can be bound to the terms of that contract. And most likely, I think we're going to see it in the consumer services area, credit, health clubs, cellular phones, that kind of thing, as well as in an employment context. I saw an interesting article the other day. It was talking about, well, it's not going to really affect retailers and their ability to limit class actions based on, defective products and that kind of thing, or false advertising, unfair competition. And then I think this fellow was playing devil's advocate. He was a consumer class action attorney, actually headed up one of the big trade associations for consumer class action attorneys. And he was pointing out that there are now going to be contracts that are put in front of people at the point of sale or flashed up on some kind of a screen before you sign in your credit card information. But I don't anticipate that that's really going to happen. In any event, I will say that right now, given the current composition in Congress, that it's pretty unlikely that there's going to be any kind of a successful congressional override. I mean, we've obviously got Republican control of the House and the ability to filibuster in the Senate, but, quick on the heels of the decision coming down, Senator Franken reintroduced the Arbitration Fairness Act in the Senate, and Representative Johnson from Georgia introduced H.R. 1873, which is the companion bill for the Arbitration Fairness Act in the House. And both of those bills would amend the Federal Arbitration Act to ban mandatory pre-dispute arbitration agreements in consumer, civil rights, and employment contexts. They have been introduced previously. I mean, this. I think everybody on the line should know this is not, just a battle that kind of fell out of the sky on April 21st or whatever it was when the decision came down. This is part of a long-running kind of, 100 years war type situation, and really one of the areas where you see most of the action. And this is a critical and important area for the plaintiffs' bar, because they, I think, really are concerned and want to preserve so much the right to jury trials in these kind of cases, so that there's potential for significant punitive damages awards. And at the same time, I think business interests have been pushing very hard back to try to get some relief from, the amount of class action litigation that's been going on. So one of the more interesting, I think, developments, and because this is an area I practice in, this caught my eye when this came out on June 16th, just a few days ago. The National Labor Relations Board has jurisdiction over private employers in the United States, subject to certain jurisdictional minimums, and basically their reaction to this decision, I think, has been quite interesting, and I think it's very instructive in that I think what we're seeing here is because the Obama administration knows that it doesn't really have an avenue to address this within the Congress right now. It's really shifting its focus to the administrative agencies that it has more control over, and one such agency, obviously, is the National Labor Relations Board, where they During periods of Democratic control of the executive, they have a 3-2 majority. And what you see now, there's this decision that came down it was a decision rendered by an administrative law judge earlier this year in January. It was a case that arose in Miami. It was a private employer. I forget what they did, but they were like, a marketing analysis type company or something like that employed a lot of people who, I think, as I recall, they kind of did telephone surveys. And there was an attorney that wanted to file a wage and hour class action. And the company responded by pointing to the mandatory arbitration provision in their agreement that banned class actions. Essentially by saying that the arbitrator has no power to consolidate or fashion some kind of a class proceeding. And said to the attorney, sorry, but you're going to have to do this in arbitration. We're going to move to dismiss your federal court case. And the attorney, in response, filed a charge with the National Labor Relations Board. And the charge was that this provision of the employer's so-called, agreement or employee handbook, whatever, with its employees, violated the National Labor Relations Act. And the provision of the National Labor Relations Act that it purported to violate was one that applies, ironically, and a lot of people don't really know this. I mean, the NLRB has control and jurisdiction over both unionized and non-unionized employers. And in this case, the employer was non-unionized. But one of the provisions of the NLRA, National Labor Relations Act, is one that governs what so-called protected concerted activity. And essentially what that means is that if a group of employees join together, even though they're not in a union per se, and they join together to protest or to do something with regard to their wages or other working conditions, then the employer cannot retaliate against them for doing so. And if they do, say, for example, by disciplining or terminating the employees, they potentially can get reinstatement and back pay. Well, here, the charge was that by adopting this policy that said you couldn't do a class action, you were violating these people's rights to engage in protected concerted activity. And in what I read the decision by the administrative law judge, it was a very kind of perfunctory analysis, frankly, and he basically said, no, I don't buy that theory. I think it's fine for them to include a waiver of class actions in their employment policies. And after the AT&T mobility case came down, apparently the regional director, or I should say the general counsel of the National Labor Relations Board, had accepted and filed exceptions to that decision by the ALJ, which means that it now is going to appeal before the full National Labor Relations Board. And I can tell you this, it's highly likely, given the current composition of the National Labor Relations Board, that that decision is going to be reversed. And ultimately, it's either going to go to appeal, I think probably at the D.C. Circuit, or I think in the 11th Circuit Court of Appeal, which has jurisdiction in Florida. If it ever makes its way to the Supreme Court, by the way, I can tell you what the result is going to be. But it'll be interesting to see what happens in the meantime. On June 16th, just a few days ago, the NLRB put out a notice requesting amicus briefs. So they're looking for input from non-parties in this case regarding whether or not this kind of a waiver should be deemed a violation of the National Labor Relations Act. So this case really bears some close attention because we're going to have here two federal statutes of co-equal I think, power. On the one hand, you've got the National Labor Relations Act. The other hand, you've got the Federal Arbitration Act. And the question then is going to be not how do you harmonize a federal and a state statute, but rather how do you harmonize two federal statutes? More difficult. We talked about the fact that we expect that there are going to be some, there's obviously going to be attempts made by the plaintiff's bar to challenge AT&T Mobility or Concepcion, try to limit it somehow to the particular facts of that case. It's a consumer class action, therefore it doesn't apply in an employment context. This is, like I said, been the 100 Years' War out here, and there has been just year after year after year of these kinds of issues related to the scope and enforceability of arbitration agreements going up and down from state Supreme Courts to the federal courts of appeal to the United States Supreme Court and back down. And I think we can anticipate that this is going to continue. But that isn't to say, however, I don't think, that it still doesn't make sense. And I think that the consensus seems to be there. If you come to the conclusion that you really do face a lot of class action risk, and you want to minimize or manage that risk somehow, there's a very good argument that this is something that you should pursue at this time. So the question then becomes, well, how do you go about doing that? And the real rule here, I think, and as Michael was pointing out, you still have to comply with applicable general state law contract enforcement standards. I guess we'll put an asterisk after that, kind of subject to Supreme Court, feelings about just how burdensome those state law standards are. You want to avoid having an unconscionable contract. The law, for example, in California is very clear that in order for a contract of this nature to be deemed unconscionable, it has to have two aspects to it. Okay. The first is it has to be so-called procedurally unconscionable, which means that it has to be a so-called contract of adhesion. And the second thing it has to be substantively unconscionable. Okay, keep in mind it's not an or, it's an and. In order for somebody to defeat your mandatory arbitration process, at least in California, they have to establish both procedural and substantive unconscionability. Now, if it's a mandatory process, it's automatically procedurally unconscionable. So, I will say one thing. If you want to have your mandatory in case I strike that, if it's not a mandatory arbitration process, if it's a voluntary one, in other words, people are given a choice about whether they want to participate in it, you have a lot more leeway to do all kinds of things in it, like limiting statutes of limitations, putting in, mandatory summary judgment opportunities for the employer, that kind of thing. That kind of stuff you can do very easily if it's optional. But if it's mandatory, they're going to look very closely at the features of the actual arbitration program to determine whether or not it is also substantively unconscionable. So if it's mandatory, you've got to pay close attention to the issue of substantive unconscionability. The case in California that sets out the standards for substantive conscionability or unconscionability is this Armendariz case. And it's been out there for 11 years now, and the standards are pretty well known. There's basically five for sure. One is you have to have a neutral arbitrator. You've got to have more than minimal discovery. There's got to be a written award. All types of relief otherwise available in court must be available in the arbitration, and the employee need not pay unreasonable costs or arbitrator fees or expenses as a condition of access to the arbitration forum. Basically what that means is the employee shouldn't be forced to pay any more than they would have to pay to go to court. So that means if there was a $100 filing fee to go to court, you can have the employee pay a $100 arbitration fee. But because they get a free judge, in court, you cannot foist a lot of other expenses on them. Generally, the employer has to end up paying for the arbitrator then. These standards came from a case called Cole versus Burns International Security Services, and I think these are basically, kind of the bellwether, features of a mandatory arbitration process that you really have to focus on. And many of the organizations that provide arbitrators, like the American Arbitration Association and JAMS in California, make these features part of their own arbitration programs that they offer. So if you're going to do your arbitration through AAA or through JAMS, you're going to have to do it with these kinds of features. In California, at least, there's also been, and also it shows up in this Armendariz case, and this goes back to something John said, which is an interesting issue, a very interesting issue. Can you carve out, and do you, and how does that kind of play into your cost-benefit analysis when you're deciding whether or not to go with one of these programs? Can you carve out claims for breach of confidentiality agreements, breach of non-compete agreements, breach of trade secret agreements, that kind of stuff? Generally speaking, those are claims that employers bring much more often than employees. And so employers want to have the ability to kind of keep them out of the mix on this thing because they want to be able to go in for injunctive relief. The problem you have with that is that a lot of courts, when they look at this substantive unconscionability analysis, they're saying, well, what's good for the goose is good for the gander. You've got to have mutuality of claims and rights with regard to claims in here, and so these unilateral carve-outs don't work. So that's something to keep in mind as well. Let's see. Another issue to keep in mind, and I'll get over this very quickly, is the consideration issue. When you want to implement this kind of program, if you want to implement it, what kind of consideration, if any, do you have to give the employees who are going to be affected by it? In many states, including California, the answer, which is an at-will state, continued employment is going to be sufficient consideration. But keep in mind that will only be the case if you actually fire people who refuse to sign the agreement or refuse to comply with it. There are going to be other states, however, that require something more. So that issue out there is going to vary from state to state. The answers to those questions are usually pretty easy to ascertain. There's been a lot of cases in the covenant not to compete context that address that issue. But that's basically what we have to say. It's a lot of food for thought, but it's an important issue that we think that all employers need to be at least thinking about at this point in light of the very great significance that this case, we believe, may have for the management of class action risk. John?
Thanks, John. Now's the time. If you have any questions, you can use the question and answer box and type in any questions that you have while I'm giving people time to do that. I should mention that in my personal opinion, a few things. First, I think this is significant enough, given the landscape that we all operate in today, that there is going to be some reaction, and there's going to be some strong reaction. The whole prospect of doing away or potentially doing away with most employment or consumer class actions would really be a revolutionary step in American jurisprudence. It would put a lot of plaintiffs' class action attorneys out of business, and so I just think the pressure is going to be enormous. And frankly, if I had to be completely objective about it, there probably will be a disincentive for somebody to bring forth a claim when there is, $15 at stake or $30 at stake. It's just the purpose of class actions is to allow group wrongs, I guess, to be taken care of in a way that makes sense. And I do think there'll be a reduction in lawsuits. So I think that'll be a push. You know, Michael, since we have a few minutes here, I mean, do you have any thoughts on that from a consumer class action perspective? Whether whether there'll be, you know, a fiery charge to do something about this, and B, whether, you know, it could really just reduce the avenues for consumer disputes?
Yeah, I think that well, I think two things. I think in the short term, like I suggested when I spoke, I think that this isn't the end of it. I literally have 5 cases right now, post-Concepcion, where people are still going guns blazing, trying to craft arguments to get around Concepcion and still argue that an arbitration agreement that precludes class arbitration should still be thrown out. So in the short term, I think you're still going to get some fights on that. I think that if you don't have an arbitration agreement and you're thinking about it, I would not be deterred by the fact that there are going to be those battles because, frankly, the payoff for you can be very significant for your company because avoiding a very expensive class action is probably worth that short dispute in the beginning about whether you can enforce the arbitration agreement. So the potential rewards are significant. So I think you're going to see some battles for the next 2 or 3 years, really as they work their way up to the federal courts of appeals to see if there are ways around the Concepcion decision. But with respect to a legislative fix, you know, this has been, as John Douglas was saying, this has been on the radar screen for a long time. When the Democrats came to power and had both control in the Senate and in the House, they didn't railroad this through. But I think this decision will light the fire under some people. They're going to want to do something about it, except if the Democrats don't have control of the House, and not to talk too much politics, but if the Democrats don't have control of the House, I don't think it's going to move anywhere. Now, that said, you know, you have your NLRB issues. You also have this new Consumer Bureau that's created out of the Dodd-Frank bill, and they actually have, that entity has the authority to sort of, well, it has an obligation to report back to Congress on how the entities that they are regulating are conducting their arbitrations and whether they think it's a burden for consumers. And after reporting back, that agency or quasi-agency has the ability to prohibit the entities that it regulates from having these kinds of mandatory arbitration agreements. That's not going to affect everybody on the call here necessarily. It could affect some, I'm not sure. But you may see, once you see that agency come out with a report, and depending on what that report says, you know, and obviously depending on how the elections go, you could see some action in a 2 or 3 year time frame. Again, I think, John, one thing I would say is I think, though, that if you're saying, well, things may change, maybe we shouldn't just do anything, I think as a business, given, I mean, if you think you've got potential class action exposure because of the nature of your business, not that you're necessarily doing anything wrong, but you know, you're doing a business like AT&T Mobility was here, it's obviously worth it to take the time to amend your agreements, a little expense there, because again, the potential, the piece that you can buy for yourself is pretty significant, and we may not see any change 3, 4, 5 years down the road. It may take quite a while.
Yeah, I would echo that. I think that with this change, think about it, everybody. If you are an employer, for example, who has a potential to get hit by one class action, if you can avoid that, I mean, you are avoiding a huge headache and you know, hundreds of thousands, potentially millions of dollars in legal fees and exposure, and your employee will still have his or her day in court, so to speak, or day in arbitration, where they can litigate their disputes. So, especially if you're a company who has a lot of employees doing the same sort of things, if you see situations where there is a common policy applied to a number of different employees, if you've had issues, a lot of EEOC charges or other issues with discrimination in the past, you know, you really want to give this some strong thought at this point. From my perspective, it kind of takes me out of being somewhat ambivalent about arbitration as being the right route to go to advocating for it for my clients, because for my clients that have a lot of employees and who have real exposure to class actions, because being able to avoid that is a real a golden ring here, I think.
I guess, John, if you've already got a mandatory arbitration process without a class action waiver, you put one in. And if you don't have a mandatory arbitration process, at a minimum, you need to look at this very closely and think about doing it.
Well, that's exactly right, John. And by the way, everybody on the phone, in light of this case, I think it's smart, and in light of the Walmart case, too, frankly, it's smart to take a real fresh look at whatever dispute resolution process you use, update some of the language, make sure it's consistent with what the courts are saying here. Now's the time to do that and to consider it. Okay, well, I think we have we're right on time here with our presentation. Again, I would strongly encourage anybody here, if they have any questions about this at all, to feel free to reach out to any of the three of us or whatever Foley attorney that you typically deal with, and ask questions. All three of us are more than willing to talk about this in more detail as you move forward. But I think everybody has, a duty to at least kind of think about it and weigh the pluses and minuses and look at this case and what kind of potential it provides for you. But again, thank you for your participation. Very much appreciate it. And everybody have a great 4th of July weekend.
Thank you all again for participating. Please take 2 minutes to complete our brief online survey. You may now disconnect.
Thank you.
Ladies and gentlemen, that does conclude today's event. Thank you for